Okay, so before we get started, I just wanted to remind everyone that today's meeting will be recorded or is being recorded. Welcome and thank you for joining us. The Greater Coachella Valley Chamber of Commerce welcomes Karen Sloat for this 2021 labor law update. Governor Newsom recently signed several bills resulting in California state labor laws to change dramatically. Ms. Sloat is here today to help us understand the new requirements and hear some excellent tips on how to become aware and protect your business. Labor Law Update is brought to you by presenting sponsor Heightened. This event is proudly sponsored by AT&T, Burtech Waste and Recycling Services, Shondi Group USA, Desert Care Network, Desert Urgent Care, Greater Palm Springs CVB, Fantasy Springs Resort and Casino, and the Cabazon Band of Mission Indians, Pueblo Viejo Grill, Riverside County Supervisor Vimanuel Perez, and State Farm Insurance Carmen Contreras, along with Southern California Edison. A little bit about Karen. Karen Sloat is an AV-rated attorney and owner of the law office of Karen J. Sloat, APC in Palm Desert, California. With a background of over 30 years of experience, Ms. Sloat and her team focus on labor and employment law. The firm's legal services include representation of clients in litigation, HR counseling, employment handbooks, policies and forms in both English and Spanish, wage and hour compliance tools, and board management training. Karen, thank you very much for being here. The floor is yours.
Thank you so much, Diana. Well, it's great to be with my Coachella Valley Chamber again. I am a resident of India, a longtime member of Greater Coachella Valley Chamber, and just appreciate all the sponsors providing the support for this important seminar. I am going to talk about a lot of complicated things. I will try to go slowly. If you have any questions or if you need something repeated, you can send a message. Diana will be watching the comments, the chats, and then I would be happy to explain things further. But the laws that govern employers and employees in California are changing so fast. We thought that COVID hit and there were some federal laws that, of course, shook our world. But even since the COVID law started to come out in March and April, even May, the legislature and the governor of California have been very busy and have put into place not only COVID laws, but laws that impact the workplace and various other day-to-day routine issues that you face. So I'm trying to get you enough information to get some protections in place. And I really appreciate the Chamber for having me do this, this quick training. So let's get started. There's me where I'm going to direct you on the screen to today's surprises include COVID reporting. Some was due in October. I'm going to describe that. There are new leave of absence laws that you need to be aware of, new pay stub requirements and pay reporting requirements. Workers' compensation issues have come up in a way that they hadn't before 2020. Workplace safety and OSHA, Occupational Safety and Health Administration issues are very important to be aware of. Contractors, huge issue. We're going to talk about that in some length. And then the Labor Commissioner, Department of Industrial Relations, has changed its rules and its methods of resolving disputes. So let's get started. AB 685. AB is Assembly Bill. SB is Senate Bill. The California Legislature, the Assembly, passed this bill, and then the governor has signed it. It is effective January 1, but it does involve strict COVID reporting requirements. Please note from the slide that if you determine that one of your employees has a potential exposure to COVID-19, you have one business day to report that to the government. So notice that what happens is you must notify all the employees at the work site. There are definitions in this law about the work site. It may be one of your locations. It may be all of your locations, depending on the definition. You have to notify the employees about the potential exposure and all available benefits, that is leave, workers' comp, et cetera. If you are involved with a union, you must notify the union. You need to notify the employees and union of any sick leave available right away, including the California Paid Sick Leave, PSL, which is the 24 hours or 3 days minimum. You need to notify the union and employees about how you are disinfecting the work site, how you're going to protect the workers in the future. Notify Cal OSHA, that's again the Occupational Safety and Health Administration, in writing. And one detour on that, there's already a notice in place that OSHA requires for any dangerous condition in the workplace. And that notice for years has needed to be submitted within 7 days. So as of now, our research indicates that if you have a COVID exposure, in addition to all these other notice requirements, you should fill out that form to notify OSHA of the potential exposure. And of course, California Department of Health and the local, to be the Riverside County Public Health Agency. All right, so also under 685, employers must give the health agencies notice of an outbreak within 48 hours. Now, an outbreak is 3 or more laboratory confirmed cases of COVID in different households within this 2-week period. That's an important definition to remember. The governor's playbook and some other regulation we'll be talking about later has an outbreak involving 4 persons out of 100. So note that this is more strict. If there's an outbreak of 3 persons, you need to notify the government again after January 1. And Cal OSHA would normally have 15 days to assess the notice, to conduct an investigation before they would shut you down. Due to the imminent danger, the OSHA can now shut down a business immediately if it determines that there's a dangerous condition on the premises. We have prepared in our firm a notice to employers, just letting you know about the COVID-19 employer reporting requirements. Of course, you can look on the slides here and find them on the internet, but essentially you need to determine whether there's this qualifying individual, that's the person who's been exposed or actually has a case. We'll talk about that in a minute. And if there's a qualified individual, then you need to notify not only these agencies, but you can see from this slide, you need to notify the employees of subcontracted workers. In other words, if you have contractors on your site, let's say it's a construction site, you have several subs and their workers have been exposed to this work site where you have a qualifying individual who is potentially exposed or sick, you must notify that subcontractor and their workers. All right, a qualifying individual is defined on this slide: a laboratory confirmed case, a positive diagnosis of COVID-19, a COVID-19 related order to isolate for this person, or if a person died of COVID. So that's a qualifying individual. If they're on your work site, just to reiterate, you need to notify the government immediately. All right, under AB 685, there can be failure to notice violations. Of course, the government can issue penalties and fines. We need to make you aware of that. And if you'll notice, I'm going to switch to the next slide. The OSHA and the Department of Industrial Relations websites are posting the work sites and the employers who report this information to protect the public. The notices that are required are not specified on these websites, but I'm giving you as much information as I can. The DIR, I'm going to do the next slide in a moment for the DIR, but they have specific information about the COVID-19 reporting requirements. Cal OSHA also has the reporting requirements available. There's no specific type of notice that I've been able to find, but you need to report this information. Does this expose your business to liability? It's possible. Clearly, if you notify everyone and their brother about COVID exposure, more people than your employees can claim that they were exposed. So keep that in mind. Of course, we're happy to help you with more information on that if you need it. So COVID-19 gap leaves. You may be aware of the Families First Coronavirus Response Act, or the FFCRA, that came out in March. It was very well publicized, so you probably have heard about it. I'll take one moment to describe it. It provided for COVID leave for your workers. For that particular statute, again, the federal statute, it provided for 80 hours of paid sick leave that employers needed to provide. Again, that was for employers with 50 or more employees, and an additional 10 weeks of unpaid leave under the Family Medical Leave Act. That's the, it was called the extended FMLA under the FFCRA. You're going to get tired of my acronyms. And that was, again, applying to 50 or more employees. It only went up to 500 employees as far as the covered employers by that federal act. So as you can see, there was a small business exemption. I've talked about this before with my first seminar months ago for the chamber. And if you have less than 50 employees, I encourage you to fill out a, excuse me, small exemption waiver form. I've provided one in other seminars. We could certainly get one to you. But if you fill out that waiver form and you keep it on file and you can prove that you're exempt from the FFCRA, then you may not have to provide this paid leave, the 10 days of paid leave. Of course, it's great to say yes to your COVID infected workers. We need to provide them with leave, get them off the premises, not have them worry about pay. All right, so 500 employees and over were not covered by the FFCRA, and gig workers or contractors were not covered. So California took care of that. California, as we'll talk about in a moment, states around the nation and a bunch of counties and cities have been able to fill the leave gap by providing more paid sick leave to workers when you have a business with over 500. I don't know how many folks today listening or seeing the webinar later have over 500. I'll go through these opportunities very quickly, but if you have over 500, you're governed by this new supplemental paid sick leave law under AB 1867. This fills the gap, again, by FFCRA. It does provide for that 80 hours or normal 2 weeks of paid leave. You don't need a doctor's certification from your worker. In fact, you can't ask for it. It is for employees who leave their home to go to work. So the question is, if you have employees who are exclusively remote, are never coming into your workplace anymore since COVID hit, and yet need leave, there may be a gap there where you don't have to provide the leave. Of course, you can offset other COVID leave benefits if you've paid your, for example, 3 already paid sick days or other paid time off. In 1867, there were other things thrown into this bill. And this is what I've noticed about these new laws that were just passed this year. They're little tidbits thrown into the bill that have nothing to do necessarily with the COVID leave. So retail food facilities. Now, employees must get a break to wash their hands every 30 minutes or more often as requested. If you are a food facility, if you provide food to customers, please educate your workers on this new law. You are governed by this law to, even if you don't have 50 employees or 500 employees, let them wash their hands every 30 minutes and post that in your kitchen or other appropriate location. The Department of Fair Employment and Housing, which is the discrimination arm of California, is creating a mediation program. That means that if someone disputes their COVID leave, wants to go after their employer, that department normally handles only discrimination and harassment and retaliation types of claims. They are expanding their jurisdiction to include COVID-related claims. And then you'll see from the last bullet point that employers with 5 to 19 employees, once they get this notice of a right to sue, that in other words, the employee has filed a complaint with the DFEH about not getting COVID leave, the department has issued a right to sue notice, giving the employee to sue your company for discrimination due to COVID, due to a COVID leave issue. You must ask for a mediation within 30 days. So please be aware of that. Mark it down somewhere. If you get that right to sue notice, ask for the mediation. It's much better to resolve the claim than face some kind of hearing or lawsuit later. 1867 also covers independent contractors. And you say, wait a minute, I don't pay them sick leave. Well, you might now. If you're a covered employer under this law, there is supplemental paid sick leave for gig workers or contractors who work regularly with your company. This is in addition to any paid sick leave. Presumably they don't have any, but there are posters to describe this type of leave, and those are available on the websites I provided earlier. On wage statements, if you provide this supplemental paid sick leave, you must note it on the wage statements. So please contact your payroll company. If you are in this category of 500 workers or more, you need to change your pay stubs. Again, this was effective in September 2020, so it's effective right away. And retain your records for 3 years, please. All right, 1867 also was a budget bill. This expires December 31. Again, this is the supplemental paid sick leave law that we just discussed. When the FFCRA expires, if it's not extended, then this law expires for this supplemental paid sick leave. Again, if you want to look for additional information, you can go to the Labor Commissioner website. It's pretty friendly. All right, now here are some questions I don't know the answer to. Obviously, you want to train and post these requirements. If someone has some kind of sick leave, let's say they're in a federal FFCRA, they have the 10 days of paid sick leave. They're within a county, for example, LA, Sacramento, some other cities have also adopted the 80 hours of paid sick leave. Well, does that mean they get 160 hours of paid sick leave? Of course, the laws were not specific enough for us to answer that question. If the SPSL, the supplemental paid sick leave, is extended beyond December 31, then there are no answers in these laws about whether something carries over. Let's say the FFCRA is extended, this supplemental paid sick leave is extended. Do they carry over some of their 80 hours? It's all left to speculation. Hopefully the DIR will give us some regulations at some point. All right, now for all employers, not just ones with 500 or more employees, there are new workers' comp laws and medical leave laws and other leave laws. So let's dive in and find out about these. Workers' compensation. You may have heard that when the governor passed a law and an executive order, and when other states, these green states, have passed orders responsive to COVID that have said workers' comp will cover your COVID leave, will cover your COVID injuries, will cover your sicknesses. Now that means workers' comp would also cover a COVID-related death. In California, that was subject to an executive order, N6220. And that means that there's a default that workers' comp will cover all of these benefits as long as you have 5 or more employees. And it's up to the employer to prove that the COVID-related condition was not contracted at work or related to any work or workplace issue. And that means, I mean, I call it the, prove that it occurred at Uncle Joe's barbecue. So take a look at this. It specifically requires an employee who tests positive for COVID within 14 days after reporting to work after an outbreak. If you have an outbreak, again, here it's defined as 4 employees out of 100 or 4% of your employee population. That's different from, as you recall, the law at the beginning that we talked about that had an outbreak at 3 persons. Sorry, they're not consistent. I didn't write the law. But if an outbreak occurs, anyone who had been there within 14 days could claim COVID-related leave. The positive test must occur between July 6, 2020 and January 1, 2023. Look at that long effective period. There's a presumption that workers' comp covers it unless the employer can prove that this person caught COVID somewhere else. The employer has a limited amount of time to prove, and the workers' compensation carrier obviously has to respond within 30 to 45 days instead of the usual 90 days to deny the claim. Otherwise, it's presumed compensable or covered by workers' comp. Okay, now this is Senate Bill 1159. If you know or reasonably know that an employee has tested positive, and let me take a little detour here. You're not necessarily allowed to ask an employee to provide you with a test or a test result. The Equal Employment Opportunity Commission, the EEOC, which is the federal discrimination branch, says that you can ask for the test results if you, the employer, paid for the test and a whole bunch of criteria. Otherwise, you have to trust the employee who comes back and says, oh, I got a negative test or I got a positive test. So if you know or reasonably should know that your employee has tested positive, you must report to the Workers' Comp Claims Administrator within 3 business days. Don't wait. This is an action item. Please just do it. The Workers' Comp Administrator will be able to advise you. We have notices in our firm for this purpose, exactly what you should tell them. But here's the issue. You do not release the employee's name. You just say, hello, I've had an employee test positive on this date, need to let you know, and file the right form. You will give them the date that the specimen was collected, in other words, the date of their test as reported by the employee, the addresses of the work sites, and the highest number of employees who were reported to that work site in the 45-day period preceding the employee's diagnosis. So this is obviously a very cumbersome law, but it is very important that you get that information to your Workers' Comp Claims Administrator right away. For positive tests that occurred between July 6 and September 17, 2020, there was a requirement that all employers had 30 days to report them. In other words, by no later than October 17th. If you had a COVID test that came up positive, some kind of diagnosis of any of your employees during that time period, please report it right now. Go right now to report that to your claims administrator. Even though it's late, I want you to avoid any penalties. Unfortunately, no, to my knowledge, not all the employers in the entire state of California got this notice, but yet it has been an obligation. Again, the same information needs to be provided as we discussed on the previous slides. Just report that as quickly as possible. All right, so again, we have a free form that just notifies you of how to report this information to your workers' comp carrier if you need it. Let's go to independent contractors, one of my favorite topics. Many of you may think that you don't have any independent contractors, but you have 1099 employees, or you have, so-and-so who had a bookkeeping business on their own, they work out of their home, and you just pay them a flat fee on a check. Many of you may not have employees who are called contractors or actual contractors, but I think this information is very critical, and I'll tell you why. I'm getting calls daily, not only from employers who have contractors who want to sign up to do work for the hiring entity, but also because these contractors are applying for workers' comp coverage. They're applying for with the EDD for unemployment benefits, and the EDD is conducting audits. As soon as I'm only about 2 cases so far, but the EDD got a request from an independent contractor for my clients. The independent contractor wants unemployment benefits. So the EDD is going back to the employer to say, prove that this person is truly an independent contractor. If they're not, we're going to dip into your unemployment benefits fund for your employees. So it's a very important issue. Let's talk about it for a moment. AB 5, which you may have heard about, was passed effective January 1, 2020, this year. AB 5 was the ABC test, and I've talked about this before in other webinars. I won't go into too much detail, but I want to refresh your recollection, as we say in the law. The ABC test was the test that the California Supreme Court had accepted in the Dynamex case, sometimes pronounced Dynamex, it's Dynamex case. And it basically determined a new criteria for establishing independent contractor relationships. The legislature passed AB 5, the governor signed it. It had exceptions to this ABC test. And then it said, or use Borrello, this 1989 case, to determine whether your contractor is a contractor. Or you can have a business to business exemption. So Number one, who's an employee? Who's a contractor? An independent contractor generally is someone who is not controlled by the hiring entity. You don't control their work. You just have them come in, do some work on their own, go back and service their other clients. You don't have any obligation to comply with employment laws if someone's truly a contractor. An employee, however, is under your control and your supervision, and you do have an obligation to comply with all labor laws. That's pretty basic, probably easy information. But there's such a thing as misclassification. What happens if I misclassify a worker as a contractor? Lawsuits can be filed. Again, agency claims like EDD claims, labor commissioner claims, DFEH claims can be filed by these people called contractors. Fines, penalties, back pay, back benefits, back taxes, withholdings. I have clients who have to go back and pay payroll taxes for these persons. There are civil penalties of up to $25,000 for willful misclassification of workers. That's not for just one, but for multiple. And then, of course, any claimant, any litigant can get attorney fees and costs and interest for their own expenses. They could get an injunction against your business, and they could require notices, public notices about your company's violations to be published. All right, so we don't want that. We don't want that. When someone is classified as a contractor, but they're really an employee, then you should think about these things. What about my intellectual property, your client names, your client contracts? What about soliciting my clients? If the person's an independent contractor, maybe they can steal my clients. Unemployment benefits, we've talked about. Your unemployment benefits are only paid in through payroll for your employees, not contractors. But now contractors are entitled to unemployment. Meal and rest period policies, do they apply to contractors? What about other policies in your workplace? Do contractors sign a handbook? Probably not. Do they get a handbook? Maybe. You need to worry about or think about the liability for the contractor's actions. If they represent your company incorrectly, if they dive into a client relationship, if they sell something to a customer, that may reflect on you. And of course, health insurance benefits for contractors, insurance fraud may apply if you're classifying people as contractors who are not. All right. So the ABC test, you might have heard of it before. A, does the company have the right to exercise control or direction over the worker's services? B, the worker's services are outside the company's usual course of business. And C, that worker has an independently established business. Pretty easy. We don't like the ABC test much because lots of contractors don't have an independent business and you still want to use them and pay them. But that was the ABC test. So the ABC test in AB5 listed exemptions. If you fit into all these folks, I'm seeing insurance agents and brokers. I'm thinking of Carmen Contreras, our nice sponsor. Lawyers are in here. You know, you can see marketing professionals. There were a bunch of exceptions. Great. They don't fall under the ABC test. They can still be contractors if they meet the Borello test. AB 2257 came out and was signed by the governor on September 4, 2020. It changed a number of issues that were already established in AB5. So in addition to the 41 current exceptions, there are 26 more, including musical artists and various other independent or freelancers that you may have hired as workers. You can look at the slide, you can find it online. There are lots of exceptions. So that means 67 if I'm counting correctly. Now, the AB 2257 changed the business to business relationships. So let me make sure you understand, because again, it's a little complicated. You have the ABC test. If they don't meet the ABC test and they're exempt, they still need to meet the Borello test. The Borello test is another 9 factors that this contractor needs to meet, unless they are a business to business relationship with you. My recommendation, always have a business to business relationship. Let's find out what that is. The contractor under this new law must provide services to the business, not the business's customers. In other words, a business to business is I have the IT person come in and fix my computers and they go back to their other clients. I have the plumber come in and fix my plumbing and then go away. It's a separate business. but they still must meet a large number of criteria under the AB5 restrictions. There are about 13 criteria for business to business. Now, AB 2257 has changed those criteria. You must get a written contract and a business license, as well as a separate location. Some employers, businesses have the contractors work in their location, and the contractor doesn't have a separate location it needs to. Here's the most interesting characteristic of 2257 for me. The AB5 had said that the contractor must have actual client relationships separate from your entity, your business, and they must be under contracts. But now, under 2257, a contractor can contract with other customers or clients. That makes it more flexible for you to retain an independent contractor who may only have one client, and that's you. All right, again, the putative employer for business to business must prove the 12 or 13 separate factors. If you issue a 1099 to an individual, please check with a legal authority, a legal attorney, because that may not mean they are contractors. That's not enough to establish a contractor relationship. So be careful. And even if they form a business entity, that's helpful, but it's not the end of the story. Remember, with any business, there are 12 to 13 factors that must be put into play. All right. AB 2257 also changed the laws governing referral agencies. I won't go into details with this because I don't even know if any referral agencies are on the web today. But if you're a caregiver or employee referral agency, please note those special requirements for you and make sure if you're using a referral agency that they meet the requirements. All right, a gig worker or a contractor who decides they are an employee and wants to bring an action under AB5, AB 2257, the Dynamics case, has a private right of action. I need to let you know there's a risk if you keep classifying these people as contractors and they're really employees. Not only do they have a private right of action, in other words, they can bring their own claim or their own lawsuit, but the state attorney general and even a district attorney may be able to bring an action for some kind of relief against a company that wrongfully employs contractors as employees as contractors. All right, my recommendation, how do we handle this issue? Self-audit your contractors. Contact any people that you pay with a 1099, any of your business clients, even the plumber, the IT person, whomever helps your business. Ask them if they, first ask them for a W-9, make sure they give you a W-9. Make sure they have all the criteria, a written contract, they have their business license, they have separate insurance, they have a separate location. Make sure they are truly contractors. If they are not, if they're Joe who's been doing your bookkeeping for years and works out of his house with no business license, convert him to an employee or tell him you must convert him to an employee to avoid any penalties. Otherwise, you're going to have to find another bookkeeper who meets the requirements. Don't assume that they fit an exemption. Please get legal advice if you need to, and contact your state representatives if you don't like AB5. All right, before we go to other leaves, I want to mention that Prop 22 has been on the ballot. As you all know, it's election week, very exciting. And Diana very sharply pointed out that there's Diana and our buddy Brandon with the Greater Coachella Valley Chamber have pointed out that 100% of the ballots are in on number 22, Proposition 22. That was the Uber and Lyft driver or professional drivers exemption to AB5. And it looks like it has passed overwhelmingly. So that means that Uber, Lyft drivers and other professional transport drivers are exempted, despite the fact that those 67 exemptions don't cover those folks. All right, very briefly, I want to talk about the types of leave that you should consider. I know this is a little confusing. I'm going to go through this quickly, but the Family Medical Leave Act applies to employers of 50 or more, right? The California Family Rights Act has applied in California to employers of 50 or more. That's changed. There's state disability leave, paid family leave, of course, COVID leaves, kin care, et cetera. How on earth are we going to keep track? Well, let's start. As of January 1, 2021, Small employers with under 50 employees, in fact, with only 5 employees, are covered by the California Family Rights Act. Please get familiar with that act and prepare yourself for providing that leave as of January 1. Previously, under the CFRA, as we call it, CFRA, employers with 50 or more employees had to provide up to 12 weeks of intermittent leave or complete leave without pay. It's job protected leave, and it's only provided once, the 12 weeks for the last 12 months, working 12 months, at least 1,250 hours. And it was within a certain mile radius. In other words, if they worked at a work site within 75 miles of your main facility. So that leave was provided, as you can see, for adoption, the birth of a child, medical care, a family member's leave, a need for leave, etc. That's great. But now the governor's just signed into law, and it will be effective January 1. Employers with 5 or more employees are required to provide this 12 weeks of leave. SB 1383, that's Senate Bill 1383, expands CFRA and the New Parent Leave Act to these smaller employers. You can't refuse to honor a request for the 12 weeks. So let me give you an example. A new baby is born to a family. Let's say the mother and father both work for your company. Each of them is entitled to 12 weeks of unpaid leave during which their job will be protected to bond with that new child. Or let's say one has a medical condition and the other needs to care for that person because it's a severe medical condition. It's possible that both persons could take off the 12 weeks. It's unclear whether they are concurrent weeks. In any event, be very careful, please, not to terminate anyone who is on this 12 weeks of job protected leave. That would be dangerous for your company. The types of family members covered by the CFRA leave has been expanded. It's not just your immediate family, as you can see from the slide. It could apply to any parent of yours, any grandparent, a grandchild, a sibling. So someone could come to you and say, for example, I need to go take care of my grandmother. Please keep my job open for 12 weeks. She has a medical condition. She needs me. After that 12 weeks is up, that same person could conceivably come back and say, now I have to take care of my sister in Minnesota because they have leave. And it's arguable, it's not clear from the law, whether the employer must keep that job open for another 12 weeks. All right, we talked about some of these, again, changes. It's just expanded, so be advised that it is expanded. If the employee has a child, it used to be that the child had to be 18 or under, and the child had to have a disability. That is not necessarily the case any longer. So an employee could come to you and say they need to take care of their adult child, and the leave may be required. All right, kin care leave has been expanded as well. Current law allows an employee to use half of their available sick leave for a family member. Now, AB 2017 allows the employee to designate their sick leave at the sole discretion of the employee. They get to say, I get sick leave, even if it's not covering a family member. Stalking leave, the leave approved for victims of domestic violence or sexual assault has been expanded. AB 2992 has done that. So if anyone comes to you and says that they are a victim, they're a witness, they have been, the victim of stalking, that kind of thing, then you need them that leave. And there are violations that can lead to liability for your company. So what do we do now? I would suggest that you get new posters, at least get posters and other notices offline. You don't have to get whole new labor posters before January, although you want to order them, but you can get posters online for these new types of leave and the revised company policies. You need to revise your actual written company policies and handbooks to reflect these new laws. You may have leave request forms that need to be revised because, of course, there are new types of leave. You do have an obligation to educate and or train your staff. If you have HR staff, they need to get some training on these types of issues to be prepared to give the employees what benefits they are entitled to, and contractors, and then hold those jobs open. Again, avoid liability. We want to protect your company. All right. As of January 1, the statute of limitations for wage claims has also been expanded. It was 6 months that a claimant, an employee, had a right to bring a wage claim before the Labor Commissioner. It's now been expanded to 1 year. And it allows for attorney fees. If an employee goes to the Labor Commissioner, gets some wages that you didn't pay them, that employee has a right not only to attorney representation by the Labor Commissioner, but if they hire their own attorney and they have incurred some cost to do so, there is a new law that allows the claimant to get their attorney fees reimbursed. Additionally, there may be appeal proceedings. You have usually only 10 days to appeal an order of the Labor Commissioner. So please be very careful about those deadlines. The Labor Commissioner will now provide representation to persons in Labor Commissioner arbitrations or hearings. So that may mean that more employers need to retain an attorney of their own and may not want to show up alone at the Labor Commissioner hearings. Very briefly on pay data reporting, new types of reporting will be required as of January 1 because the EEOC is looking into equal employment opportunity. In other words, they want to make sure that males, females, persons of different cultural backgrounds, race, gender, etc., are all getting equal pay. So it's difficult because people may ask for different benefits, pay their health insurance through their pay, etc. But if you're governed by this law, you need to provide an EEO-1 form to the Equal Employment Opportunity Commission and also report this pay data. This is only for California employers with 100 or more employees. Again, I don't know how many employees you have, but the reports are starting in March and they're very strict criteria. So please check with your payroll company and report that as needed. All right. A few more thoughts. In 2019, as you may have heard from your sexual harassment prevention training, which is due January 1, 2021. In 2019, the laws were expanded for claimants of sexual harassment. Now, let me explain that for a moment. Claimants, employees who had been allegedly sexually harassed in the workplace previously had only 1 year to bring that claim to an agency, the Department of Fair Employment and Housing. And they only had 300 days to get their claim to the EEOC that we've discussed. And then after that, they had to get a right to sue notice and they had another year to file. Last year, that law was expanded in California so that a sexual harassment victim will have up to 3 years to report the alleged sexual harassment to an agency. What's unfortunate about that is that you may not have the witnesses available to you as the employer any longer because they left 2 or 3 years ago. But I want you to be aware of that. They have 3 years to file. There has been a restriction on a no hire clause in a settlement agreement. For example, if an employer and an alleged harasser who's employed by that employer settle a case by an alleged harassment victim, normally we enter into a settlement agreement, we protect the employer, and we say we don't have to hire, there's a no hire provision, we don't have to hire that sexual harassment alleged victim in the future because we're giving them money in exchange for their claims. That no hire clause was deemed to be illegal, unlawful, so you couldn't put no hire clause in any settlement agreement, but you can put a no hire clause in a particular agreement involving an alleged harasser, a sexual harassment claim. I do want to mention that there's still a deadline that has not been extended by COVID laws to get all of your subordinates, all of your employees trained in sexual harassment and abusive conduct prevention by January 1, 2021. There are a number of programs online you can use for that. Our firm provides training, the 1 hour training. It's only 1 hour, but it must be provided before January 1. So don't forget. I am available for questions. I believe they're going to be routed through Diana. If there are no questions, I can mention a few new laws, but I think I've probably saturated the audience with new information.
That's a lot of great information. Thank you very much. I think that one of the biggest questions was on the extension, and it had come earlier on, but you did address it as well. That's the concern, is that we don't know how far along these will be extended. But it seems like,
Right.
like you covered them on various rules there. Brandon, I think you had a question that came through email.
Yes, we did. Hold on 1 second.
That get addressed. Most of the questions that have come through have been addressed.
Yeah, I think you may have touched a little bit on this, Karen. We had one of will essential workers see a pay increase or bonus, if there's anything regarding that.
Essential workers will see a pay increase. Well, I would say there are special laws for the health field and the first responders. Whether essential workers will automatically get a pay increase. Essential workers is a tricky term. That could mean, I mean, my law firms stayed open to provide this essential COVID information for others. I suspect they mean the first responders. And I don't know if they'll get a mandatory pay increase. I do know that they were the first ones to get that workers' comp coverage for any COVID related symptoms and leave.
Okay.
I do have another, and the question is, are there templates available in order to update all of the employee manuals with many of these new rules and regulations?
Great question. I can only, I don't mean to, I'm not self-promoting, but I just want you to know, we take a long time to develop our manuals, our handbooks, and especially this year, we are implementing a number of very large changes to our handbooks. So I don't know of any templates available for free. You may look online, but because California is so specific, I recommend you get some legal advice or an HR consultant advice on expanding your handbooks, because they will need to be changed. We have, in fact, said right now that we're not doing any updates of our handbooks before the end of the year, because all the new laws take effect January 1. So we're delivering handbooks starting January 1 to make sure that we get all those new provisions in, and not only the handbooks, but the notices, the posters, the forms, as I mentioned, personnel forms will need to be changed as well.
Yes, for sure. We do offer, on that same note, we do offer the posters via the chamber. So we will be sending out a link on our social media platforms and to our membership in the next week and a half or so on that information as well. Along the lines of updating the employee handbooks, once it's updated on January 1st, 2021, with as quick as the rules and regs and laws are changing, how quickly do we need to turn around and make our employees aware of this? I mean, I foresee addendum after addendum after addendum every 30 to 45 days at the rate that we're going, especially with all of these changes. Or is that just being hypervigilant?
That's a great question. I will say traditionally in my years and years of practice, that around September and October every year, the governor would sign, or September 30, ironically, almost every single year, all the past governors would sign the new laws. And so if we would have October, November, December to get all the handbooks changed with a few updates, and then post them, January 1st. 2020 has been, the year of years, right? So aside from all the COVID laws, there are extra laws. I would say it depends. If COVID dissipates and we don't need as many COVID related protections, then we should have 1/10 of the laws passed next year, I would hope. And they won't come out as fast. This year we had March, new laws in April, new laws in May, June, July, all of a sudden September, they're new ones. It's been very unusual. So hopefully next year will be much more normal, and we won't have all those addenda
Yeah.
after the first.
That's right. Those laws were being introduced faster than the latest iPhone, I tell you.
That's right. It was. They were. Great point.
And that's the reason why I posed the question, is because it's been unlike any other year. No sooner were we wrapping our arms around something when it was an additional consideration. And to communicate all of that to our business membership is also something that we needed to stay on top of. Not only communicating it correctly and effectively, but just constantly feeding that information and overwhelming that for business owners, especially smaller businesses.
It is very tricky. We have, for the most part, the CDC and OSHA, I would say, were mostly consistent, at least with the COVID regulations. But the forms, there is a different form for every agency to, submit a report. That's tricky.
That's for sure. Once again, let's see, do we have any other questions from the audience? I don't see any.
We did have one more, and it's not a big one. I did remind them that we will be publishing this both on Facebook and YouTube. But Karen, right. We did get a request if the presentation would be available for people as well.
Sure, the PowerPoint, of course. Yeah. If the chamber doesn't provide it, you can see right on the screen. Just email us at info@karenslottlaw.com. We're happy to provide the PowerPoint presentation, get you the information you need.
Okay. And then there was something that just popped up on the chat, and then we'll wrap it up with this, is that there is a mini wage increase that is scheduled for 2021.
That's correct. That's okay. Correct. On top of everything else. That's right.
And that is
sorry, go ahead.
What month would that be? I'm sorry, there's a lag. What month?
That would be That would be January 1. There will be an increase, and note that it will also affect your exempt salaried workers. So don't forget to increase your salaried workers as well as the hourly.
Okay. Well, thank you so much, Karen, for your time and attention. And I believe that we are going to revisit all of these issues within a short period of time, and just continuously make sure our membership is well aware of any changes, and make ourselves available here at the chamber along with you, any questions they may have or any guidance they may need with forms and so on.
Good. Happy to help. Thank you so much for the opportunity to educate people today. We appreciate it.
You're welcome. You're welcome. Thank you once again for all who attended, and thank you once again to all of our fantastic sponsors who make these events available. This session has now concluded.
Thank you, Dana.